Thank you, Senator Fisher. Senator Markey.
Thank you, Mr. Chairman, very much. And we thank you, Bonnie Lautenberg, for being here and bringing Frank Lautenberg's great legacy of fighting for toxic protections to us. And the job that we have on this committee is to make sure that there is a bill that does give protections for the next generation that we have to put in place, learning the lessons of the past. My first question, the Massachusetts Toxic Use Reduction Act is a multifaceted pollution reduction law that has been successful at decreasing the amount of toxic waste in Massachusetts by 50% and spurring innovation of safer chemical formulations to replace other more dangerous ones. The Massachusetts Attorney General, Maura Healey, recently sent me a letter describing the way state authority to set strong chemical safety standards and enforce existing laws is preempted in the Udall-Bitter bill. The letter also highlighted the concerns that this bill could preempt actions taken under the Massachusetts Toxic Use Reduction Act and could further be used to interfere with state action related to water quality, air quality, or waste treatment or disposal. Do you agree that all of the erosions of state authority described in this letter are in fact enabled by the bill's text?
I think that the Massachusetts Attorney General accurately characterized how preemption would work as it relates to state requirements.
So the answer is yes, it does accurately characterize the impact on state enforcement. Next question on preemption. The Udall-Bitter bill says that as soon as EPA starts to study a chemical it has designated as high priority, states are prohibited from taking new actions to regulate that toxic chemical. Since the bill also allows EPA as long as 7 years to finish work on each chemical, do you agree that this could mean that there will be no protections that chemicals on either the state or federal level, potentially for 7 years or longer, would then be in place?
Yes.
Next, the Udall-Bitter bill allows the chemical industry to pay extra money for EPA to classify a chemical as high priority. Do you agree that this provision could be used by the chemical industry to stop a state from moving forward with plans to regulate a dangerous chemical, because as soon as EPA starts to study a high-priority chemical that would be paid for by the chemical industry, that states would then be prohibited from regulating it?
Yes, I would just say that the bill appears to have a cap on the number of times that EPA could do that as 15% of the total number of high priorities, but the answer is yes.
The answer is yes. So the chemical industry could pick those chemicals that would not be, in fact, subject to jurisdiction by the states. Next, the Udall-Bitter bill requires EPA to begin working on the first 25 high-priority chemicals in the first 5 years after enactment. How long would it take under the bill for EPA to have to complete work on those first 25 chemicals? And just to be clear, EPA has to start work on 25 chemicals 5 years after enactment. Each chemical studied can take 7 years to be finished. So the study on a chemical that begins in year 5 after enactment will then not have to be finished for 12 years in total. Is that correct?
That's correct.
That is correct. Next, if it takes 12 years to finish work on the first 25 chemicals, do you agree that given the Udall-Bitter bill's pace and today's methods for assessing chemical risk, it will take more than 100 years to finish studying the 1,000 chemicals that you have previously said were the most in need of assessment?
If EPA stuck to the minimum requirement in the statute for that entire period of time, the answer would be yes.
Next, Flame retardants are widely used in commercial products like couches, clothing, and cars. EPA has expressed concern that certain flame retardants which can leach from consumer products are persistent, bioaccumulative, and toxic to both humans and the environment. Question: does the Udall-Vitter bill make it more difficult than existing law for EPA to regulate a chemical like flame retardants in a couch or chair even after EPA has found that the chemical is unsafe?
This relates to the articles discussion we were having earlier. The draft bill creates a fair amount of analytical burden related to any time we're looking at a chemical in an article. That aspect would make it more
It does make them do a separate analysis for every type of product that contains that chemical. Right. You're right, separate analysis. And finally, in 1989, EPA tried to ban asbestos under its TSCA authority. But the industry successfully overturned the ban in court, in part because the court found that EPA had not met the substantial evidence standard that TSCA required it to meet. The Udall-Vitter bill does not change this standard, even though it can be a much harder standard to meet than the one used in other environmental laws. Question: do you believe that the use of this same substantial evidence language that has already been the subject of litigation would increase the likelihood that EPA would be sued using some of the very same arguments industry used successfully to overturn the asbestos ban?
Our legal team is observing courts are treating substantial evidence and arbitrary capricious similarly. That being said, I would expect that a company that opposed the Section 6 rule would try to make the substantial evidence arguments that were made in the asbestos case.
And again, asbestos is front and center. We have to be very careful what we do here to make sure that there is true enforcement.
Thank you,
Thank you,
Senator
Mr. Chairman.
Markey. Senator